The question is that the motion be agreed to. The Honourable Nanaia Mahuta.
Mr Speaker, Labour is pleased to be able to support the progress of this bill through the House and the consideration of the Select Committee on what is some small but integral steps in modernising the legislation. I didn't sit on the Select Committee, however, I know that from the considerations and having read some of the submissions, it was clear that the committee took seriously some of the fundamental aspects of empowering dock rangers by way of allowing and broadening their ability to intervene, stop and retain people for illegal purposes. So I just wanted to summarise a couple of those submissions. Firstly, the Legislation Design and Advisory Committee and the suggestions they made around the scope of search and stop powers to ensure that the objectives of the bill could be achieved while keeping in mind the balance between individual rights and conferring rights to dock rangers. I think they made some helpful suggestions which the committee and dock officials reflected on, and you can see that through the amendments that have been suggested to the bill. The Minister is right, protecting New Zealand's biodiversity does matter. And when we think about New Zealand and our conservation estate and the rich biodiversity that we have throughout, which we can share with our children, the next generation who are part of protecting and cherishing the estate, it is only right that we try and ensure that dock rangers have the types of powers that stop people basically blundering and taking illegally our natural wildlife. And for that reason, I listened carefully, read carefully the submission by New Zealand Fish and Game, and I did happen to be on one small part of a hearing where they were there, and they argued against being excluded from the provisions of the bill. I think the committee in the end deliberated on this matter, but landed in the right place. Some of the conversations that we had when I was at the Select Committee were largely New Zealand, the Fish and Game honorary rangers are just that, they're voluntary. They don't have statutory powers. It would be difficult to try and confer significant powers on a group of people who, quite frankly, we did have the discussion in the public submissions where there could be a rogue ranger and they could just go all over the show with the powers. And I think the committee in their good conscience weighed up the submission from Fish and Game and balanced that with some practical applications of what was intended in the legislation and really narrowed down the powers here. Also, the New Zealand Law Society gave a very useful submission, and they wanted to stress and ensure that the powers that were being conferred in this bill aligned to the Search and Surveillance Act, and that has been the case, and you can see it in the committee's report back to the House. So the ministers pretty much were covered extensively the things that were considered: the power to search, seize evidence, the power to stop a person, in addition to the existing powers that already are there for dock rangers, and the power to intervene to prevent offending. Those kind of were the key aspects from the report that many of the amendments focused on. So the issue of dock rangers and approved officers having the powers of arrest. One of the interesting points that the report notes is that they've narrowed the scope, or the potential for interpretation of the scope being too broad in the way in which these powers were going to be conferred. And I think all in all, that suggestion has been a very useful conversation of the committee. When they heard the, noting in the report that they heard a number of submitters and made various recommendations, clarifying the classes of rangers was very important. And again, having only sat in on the submission from New Zealand Fish and Game and identifying who was intended to be covered by the Act and therefore who wasn't, was very well specified within the amendments being proposed. Making clear that rangers can seize evidential material and the extent of that evidential material, aligning those powers to the Search and Surveillance Act, again, gives greater confidence to the way in which the bill, the Act, is intended to operate. And you know, one of the things I remember in the first reading debate was the fact that we have dock rangers out there doing great stuff and often by themselves, and we want to make sure ultimately that in carrying out their role and conferring extra powers of this nature on them, that they are safe, that they are able to conduct these types of duties and obligations in a way that will protect them as well. One of the other aspects is the issue of requiring a person to stop and how long would you retain them. And I'm sure that was a healthy conversation, and I know a number of colleagues at the Select Committee will probably comment on the issue of retaining people and for what period. In the end, reasonableness became the operative word and being reasonable in that manner. I wanted to spend some time to comment on the type of information being obtained in order for a prosecution to take place, requiring that date of birth material information is obtained. This is a matter that I know my colleague David Parker, who was on the committee, wants to raise in the committee stages of this process. And that's really to ensure that if you are going to pursue evidence which will potentially lead to a prosecution, then you've got to make sure that all those types of information and the people who can collect it are able to do their role. And I understand that there was some discussion around the extension of fish and game rangers being able to obtain this information for that purpose. It had occurred to me in listening to the Minister's speech around this, and it purely was from a safety aspect, about whether there would be some kind of review around the way in which certain parts of the dock estate at certain periods of the year might be better supported because there is maybe a trending of activities and things like that. That's an operational decision. I understand that, but it will be, if we're going to have a bill that increases powers to dock rangers to be able to intervene, stop illegal activity, then looking at the operational aspects of whether or not capacity needs to be increased in various parts of the dock estate is probably a natural consequence of these powers. Finally, I know that the bill will go through its committee stages, and there will be some useful discussion around the narrowing of the powers as suggested by the amendments by the Select Committee. And there's ample time for that to be discussed through the committee stages. But can I say, from my small part in the dock estate that is within my own electorate, we're very grateful for the good work that dock rangers conduct within our area. Over the summer period in particular, you see a natural increase of many Kiwis enjoying the dock estate and offering to help in the activities of dock rangers where they can. Just at the back of my house, they're improving the tracks there. If you're up for it, there's a great walk with a number of steps, and if you're up for it again, you can help take stones up the upper stairway called the Hakarimata Rangers Minister. But can I say that insofar as the dock estate is concerned, these small amendments, albeit small, are useful amendments for dock rangers, because at the border, when you see eggs being smuggled out, when you see things coming illegally into New Zealand, reptiles and the like, you realise that we have the luxury in New Zealand, surrounded by ocean, to be able to protect what we have here, to be able to ensure that we can stop wildlife from going out elsewhere as best we can. And in order for that to happen, amendments like this are very practical and useful to achieve that purpose. Kia ora.